Not legal advice. Good afternoon as I wiggle around. Hope you're having a great day. And obviously, not legal advice. Like, subscribe. Please subscribe if you get anything out of this. And please subscribe if you don't. Again, please send loads of cash. All will be accepted. Just kidding, of course. Not legal advice today. We're going to be discussing three main topics. Because there was a story on Politico about Alpine, we're going to address that. I'm going to address the DTCC and their bond, and I'm going to address MMTLP and a filing. And before I get that way, I would just throw a condolences out to the members of the MMTL community that we lost, including Tony, Susan, I think Ben, I believe, and others. And I know the others who are suffering. So it does not go unnoticed. And I just wanted to recognize that. And obviously, I was impacted by it as we all were. So I'm going to leave that. And I believe one point I wanted to address was a Freudian slip is when you mean one thing, but you mean your mother. Anyway, so there was a lot of discussion today, or at least I saw it, about Politico posting an article about Alpine and FINRA and whether that was going to be the end of FINRA, and I'm summarizing, of course. So Mr. Tiny JR and I have discussed that at length in some of our live streams, and I've put out numerous uh, videos about it, but I'm going to briefly address it just so it's clear. So prior to April of 2022, Alpine had been cited for violations where they had been convicted or either admitted on 40 different occasions from 1984 forward through 2022. There were various violations, including basic, stealing, not supervising, improper reports, etc., a whole litany of things. But on 40 separate occasions, they were cited. So they were known to be misbehaviors and not reliable and not acting according to the way the business should have been operated. And then we have in 2022, we have a hearing, and they're found to have committed other violations, including misappropriation of money, etc. Cease and desist order is placed into effect. A year passes about, and then FINRA tries to go into their administrative tribunal to get them expelled for violating that April 2022 cease and desist order. And the claim is they had 35,000 violations. No explanation, by the way, why it took FINRA a year to go after them for all those violations, but so be it. Those are the facts. So proceedings start, and there was already a lawsuit that had been filed by Alpine versus FINRA attacking their constitutional authority to go forward. So after, in 2023 now, after FINRA finds out about the shenanigans and violations, then they try to proceed to get rid of Alpine. Alpine has that case going from October of 2022, October 2021, and then goes into court and asks for an injunction. The court initially denies the injunction. It goes up on appeal in a 3-judge panel, 2-1. That panel grants the injunction and asserts that there is real constitutional issues as to FINRA's operation here. And that is being briefed currently on appeal. There's another maneuver that was made, but there's no decision on that. But the briefs regarding the appeal as to whether there should be an injunction ultimately, and ultimately whether there's any constitutional validity to the arguments made by Alpine, will be briefed and heard over the next few months. So that's ongoing. But that does not change the misconduct of Alpine. So while and Alpine's challenges to FINRA's authority are constitutional, that the appointment of the judiciary, let's say of FINRA, is inappropriate and constitutionally improper. There's a non-delegation uh, uh, argument and some other arguments, and basically constitutional arguments, which the Court of Appeal has found at least good enough to give them the injunction. Whether they find in their favor, we don't know, but that's the direction the court is going in. So just following this down the road. So if the Court of Appeal found that the appeal should stand, then they could throw out the initial findings against Alpine. FINRA would then take that up to the Supreme Court, which probably would hear this case, I think. And they would make a decision whether FINRA had authority to hear these cases. Basically, a very broad case. So that could go forward. But in the meantime, what could happen and what I've been trying to get to happen, and that's what the Politico argument article said today. They were talking about the case that Alpine is making in the Court of Appeal as to the authority of FINRA. But to add on to that, if FINRA proceeds through the federal court, many of the arguments that are made by Alpine cease to exist. So if FINRA wanted to swallow its argument as to its authority as an administrative agency to operate and would just accept that it should proceed through the federal courts, then it could, and immediately could go into federal court today and cite all the violations, because apparently there's 35,000 plus violations of the 2022 order, and the public is deemed at risk from those actions. So it seemed that it would be pretty easy, if those are true and factual claim violations, it seems pretty easy that they could go into court and get the appointment of something analogous to a receiver, a third party to take over the business, manage the business, write checks, do what's right. And it seems if somebody was able to do that and replace Alpine's management, that would be a big step forward. Now, again, I don't know if that's going to impact the stock price. There may be other events. It still may not impact the stock price. But the question that is up in the air is what procedural is happening to Alpine in the courts. So again, we have an ongoing appellate proceedings that will determine if the injunction is valid and will also determine if FINRA has the constitutional authority to go forward. At the same time, and again, I urge FINRA to go into federal court, use the violations that occurred by Alpine during the time period after April 2022, and get a receiver appointed to protect the public and to move this on. There's nothing to stop you from that. And the argument, again, that because this is my concern, that this is the argument, that FINRA won't do it because they don't want to acknowledge that the federal courts have primary jurisdiction over their SRO, and because of that, they don't want to go into federal court, and they want to see how it rolls out. That's not helpful to retail shareholders, and is part of the problem. So again, I urge everybody out there to contact FINRA, contact the SEC, contact whoever you have been to this point in time, to urge them to have FINRA go into court to protect consumers. So there's nothing new in terms of Politico. It's an ongoing action. We've talked about it. The first brief will come out sometime the end of this month. I will brief you on the brief, and we'll follow the briefs forward. But there is definitely a potential outcome that FINRA could lose authority, which is fine as long as something fulfills and fills that vacuum. And we don't know that at this point in time. We'll have to see how that works out. But that's kind of where we are. So nothing new, no new filings as of today, and just putting Politico's article in its proper perspective. It's not new, and it has been addressed, and we will continue to address it with you. So that's number one. Number two is the DTCC. They have put out a request, and it appears will be granted, to have the ability to raise money through a bond, through selling bonds, and the amount they can do is up to $5 billion. And the way they specify it is it's pre-funding uh, liquidity. In other words, it's for paying certain debts that may be coming, and it's obviously in addition to what their existing funding is. And I was looking at their existing funding, their last year's balance sheet. I think it was last year's balance sheet. I was looking cash on hand. They had something on the order of $16 billion, and members, because members are all the banks, broker dealers, etc., who are their participants, and they put monies into the fund also. And there's about $31 billion of participant money in there. So collectively, it's about almost $50 billion. And then they have a line of credit on top of that. I don't know what the line of credit is. Uh, it's it's because it's not specified, or at least in the documents I saw, it was not specified. And then on top of that, they have all these cross-collateralized, I'm calling them cross-collateralized agreement, but there's a bunch of other agencies. And all these agencies have agreed to be partially responsible, because what the DTCC is responsible for final settlement of trades, transactions. So it has a lot of assets at its disposal. But there's a bunch of other agencies that also are involved to do other various tasks. And I'm just going to name a couple: the NCCC, FICC, but there's a litany of those, and they all have agreements with each other, so that if they can't satisfy an obligation, then the others would come in and, based on some calculation, would be responsible for some amount of money, and then the original organization then would dip into certain other funds, there may be insurance. And on top of that, what they're doing is raising $5 billion or up to $5 billion for bond funds to cover, I guess, expected future obligations. We don't know what those are. $5 billion is not a huge amount, but they have a lot of, if it's in addition to their existing amount, which is a substantial amount, then they must be anticipating some big hit, it appears. So I was struck by that. I was struck by the fact that it was $5 billion. The documentation is not clear other than that, and other than the fact there's a lot of guarantees. And ultimately, by the way, if that group isn't able to satisfy a debt that the group is responsible for, they're a member of the Federal Reserve System, and I think they're going to be deemed too big to fail. So I think no matter what the nature of this extent of the obligation, for example, if it was determined on day one that MMTLP, Gtii, and finra all had to be satisfied, there is obviously a means for satisfying all of it. And it's clear from the balance sheet and from the financial documents. What's more interesting, again, is that $5 billion new bond issue, why they're doing it. Does it replace some other line of credit? Because they have a line of credit also. Are they anticipating something specific? Have they run out of equity? It's interesting. It'd be interesting to find out what the real answer is in conclusion. But I was struck by the fact they were doing that, and I will keep you apprised as I learn more. Last but not least, I wanted to touch on MMTLP. I'm involved in arbitration, and I have recently filed an action against AST to obtain the share count that AST has of MMTLP and/or NextBridge shares in any fashion, held in any manner, currently by AST. That's all I'm seeking. It's just that particular share count. Action's been filed. It's out for service. Separate and apart from that, I'm involved in a arbitration with Fidelity. I almost forgot what I'm involved with. And I received an answer a couple of weeks ago. I was pissed off by the answer because it was very dismissive of the claim and of naked shorting, or claims about naked shorting, and about issues involving an investigation, etc. I waited a couple of weeks. sent a response in to I really toned down my thought process. And again, handling is just between you and I, don't tell anybody else. Although, like I always say, these are best watched by dogs in particular because they do like my videos. But between you and I kind of waited to because I wanted to tone down what I said because I was annoyed, especially in light of events that happened this month with members of the community. I was more than annoyed, and so what I'm doing is I'm giving you a portion, very small portion, of what I submitted. I can't release the documents because the proceeding is confidential to some degree, and we haven't yet picked the arbiters. I don't want to piss off the arbiters before we start. So I can talk about what's in my papers. I have no problem with that, and will do that. But I don't want to release the contents, at least at this point in time, until I feel confident about what the position is of the arbiters. But just kind of two little quickies about what I indicated in my response to their answer. And that's not a document that's necessarily called for, but I figured I'd want to put it on the record. So the first one I wanted to reference: the dismissiveness and the false assertions that there is no merit or evidence of any naked shorting nor any evidence of investigations is very disturbing. Plaintiff will not let defendant spew unfettered BS. This is especially true as many members of the MMTLP community have perished, suffered divorce, lost homes, suffered extreme anxiety arising out of the trauma intentionally inflicted on hardworking Americans by the predators arising out of the gutter, and then in parentheses, like defendant Fidelity. And the other quick portion I wanted to read was Fidelity's counsel, which is a very reputable and large law firm. In their answer, cited the article, I think it was the Forbes article by the author was B. Kajodian, and he said the claims were loony. I think that was the title, Loony Claims or something like that. They attached that article as part of their answer. So I addressed that briefly in my response here too. Besides making him a proper target for discovery, the writer, BK, who is seemingly a paid gun who asserts a position without reality to the facts, belittles, extinguishes, and downplays the likelihood of the existence of naked shorting, and asserts the claims are from loons. He fails to address, however, the findings in the Dole Pineapple case, the SEC's indictment of savvy management for naked shorting just weeks prior to his article, the Sorrento Therapeutics case in Texas prior to the time of the article, where a federal judge specifically identified naked and counterfeit shorting. Additionally, the attack dog obviously did not know what Congress felt about the illegal conduct as reflected in the attached congressional letter. Per BK, everyone but him is a loon, and despite objective evidence of illegal conduct, the man motivated by greed is wearing blinders so he can seemingly opine nonsense for defendant. So I read you just two portions of my response, of my toned down response under the current circumstances. So you can gather that I wasn't overly pleasant, nor do I feel particularly pleasant to counsel for Fidelity at this point. Anyway, I'll keep you apprised of that also. So I filed an action against AST. I filed this in response to the answer and am finishing up a motion for discovery based upon the extraordinary circumstances as reflected in the U3 halt, and I will keep you apprised of them all. Be well, take care, have a great day. If I could turn this thing off.